Passover case from supplementary list, item 3, second appeal 34 of 2007. Mediation.
Are you interested in mediation? Sorry? The learned counsel for the respondent submits that the party is not ready for mediation. Sorry? That's right. कब करना है बताइए? At his request, the matter is directed to be posted for final disposal on 11th March. चलिए.
Passover case, item 6, second appeal 140 of 2007.
Yes. With the consent of the learned counsel for the parties. Sorry? The matter is referred for mediation. The counsel for the parties submit that the parties would appear before the learned mediator in Jhalsa, are ready to appear before the Secretary Jhalsa on 11th March? On 12th March at 11 a.m. The Secretary Jhalsa is directed to appoint an expert mediator. Let this order be communicated through fax to Secretary Jhalsa.
Passover case, item 9, second appeal 202 of 2007.
Yes.
Cannot be
The counsel for the Pilan submits that the matter may not be sent for mediation. Second appeal है, substantial question of law framed है, पार्टी का appearance complete है, कब करना है? Yes. With the consent of the learned counsel for the parties, let this matter be posted for final disposal on 18th of March.
Passover case from bail list, item 9, BA 10570 of 2025.
Yes. Petitioner is again absent.
Yes.
BA number 10570 of 2025. Nobody appears on behalf of the petitioner. In the first half, when the case was called out, nobody had appeared on behalf of the petitioner. Accordingly, this bail application is dismissed for non-prosecution. Sorry? Counsel for the state is present. Communicate कर दीजिए.
Passover case from bail list, item 18, BA 10718 of 2025.
आप हैं इसमें? सेम ऑर्डर कर दीजिए. स्टेट भी एब्सेंट.
From bail list, second half, targeted case item 1, WPC 1175 of 2003.
Yes, petitioner.
In this case, we have challenged the order
order which is passed by the revisional case filed by the petitioner by the South Nagpur Division Commissioner, which is order dated 18/10/2022, very much the revision which was referred by the petitioner against the order passed by the additional collector that has been dismissed. And we give the brief facts of the case.
The matter is regarding what?
Regarding on the mutation, which was allowed earlier by the classman officer on the basis of application filed by the petitioner, which was challenged later on by the respondent, private respondents, after 8 years before the additional collector. The additional collector allowed the appeal, and thereafter we preferred the revision that has been dismissed by the revisional authority.
So what is your point?
The point which I wanted to point out in mentioning the instant matter, Lordship, is that the petitioner, he purchased the father of the petitioner number 1, petitioner number 4, Lordships. They purchased the land from the legal heirs of Dushan, who was the recorded tenant of the land in question. The land was purchased by a sale deed dated 7/12/1988.
So?
After purchase of the sale deed, the land in question, the father of the petitioner, petitioner number 1 and 3 and petitioner number 4, they applied for the mutation for the concerned authority.
Your vendor had the mutation in his favor?
Lordship, that they are also not disputing. They are saying that they are the descendant of that recorded tenant.
Who are the descendants?
Dushan, from whose legal heirs the father of the petitioners purchased. They are saying that they are the descendants of that Dushan, and they have the possession and the title over the land.
I don't get it. If they have sold it.
They have sold it, but they are not saying that they being the other legal heirs, Lordship, of the original tenant. So they also have
Other legal tenants. So there has been no partition.
Lordship, that's because that part is concerned. That is not know whether there was partition or not. All that I wanted to mention, my lords, that the father of the respondent number 5, my lords, Muniram, he had filed a suit against my lords, the father of the petition number 1 and 3 and my lords, the petition number 4. That suit was dismissed by the learned trial. That suit was my lords, for declaration of right, title and interest, and for declaring that the sale deed by which the petitioner got into the possession and the title over the land in question, that is null and void. That suit was dismissed. That fact we brought before the revisional authority. The revisional authority said that we are not concerned with the judgment passed by the trial. We will not look into the if you also kindly see the
Show me the first order.
The first order. The first order Lordship is Annexure 1.
Read it, please.
Is the Khasmal officer who is passed the order.
Khasmal property can be sold without consent.
It was a righty property.
Khasmal officer is doing it.
Khasmal officer, because in that very area where the land belongs, before 2000 mallards, the concerned officer was the Khasmal officer who used to pass the mutation orders. Post 2000 mallards, circle officer has been given the power to pass.
The original order is in your favor?
That is in my favor.
This was set aside by the appellate authority?
By the appellate authority.
Read the original order.
The original order was that Annexure 1.
Yes, read it, please.
इश्तेहार 17/7/1989 इश्तेहार के पश्चात आपत्ति पत्र प्राप्त नहीं हुआ। हल्का कर्मचारी ने जिला कानूनगो के माध्यम से जांच प्रतिवेदन समर्पित किया है। आवेदित भूमि खाता 48 जमाबंदी वॉल्यूम के पृष्ठ 48 में विक्रेताओं के पिता के नाम से दर्ज है। विक्रेताओं द्वारा दिया गया शपथ पत्र एग्रीमेंट किया है। शपथ पत्र में वर्णित है कि विक्रेताओं ने जो खाता 48 के रैयत धर्मदुसाद के उत्तराधिकारी हैं ने विक्रेताओं को दखल
दर रैयत
हलाल दुसाद के उत्तराधिकारी हैं जो बिक्री किया है।
Who is the Dar Rayyat? Dar Rayyat has no right to sell the property.
That they are challenging for the trial court, that has been dismissed. That suit has been dismissed. And to our knowledge, they have not challenged that order.
You see, even if the sale deed is not set aside, the Rayyat, whatever he had right, he doesn't have a right to sell the property, isn't it?
But there is a order passed by the court of law, which
says that the Rayyat has got the right to sell the property.
If I may please the, although we have only
Okay, what happened before the appellate authority?
The appellate authority was these matters Annex 3, dated 30th October 1999.
In this case, initially I was appealing. Subsequently, both the parties have settled their dispute. I was informed that we have settled. Now you don't have to appear because original respondent is no more. Now substituted respondents have informed me that we have settled. Like if you have settled, it is to be settled in the court.
We just do not know if they have settled, not settled. They are arguing the case. We are hearing the case. You have the wakalat that's
earlier we had received instruction of settlement. We had informed them also, but earlier lordship, perhaps they were not informed about the settlement by the client. So since they were not informed, so we were proceeding with the matter on merit.
Yeah,
but we have also instructed the lordship.
They have said we have settled our dispute.
You don't decide to mediation if the lordship services can be. Because we were informed about the settlement, but they were not informed about the settlement.
You have the number of your client?
Lordships.
You also have the number of your client?
Right now I am not having, but the lawyer concerned is having. He is in touch. I will.
You have been informed that the matter has been settled?
He and even once client talked to me, कि we have settled. लेकिन हमको फिर उसका कोई इंस्ट्रक्शन नहीं है कि they have also. I think if the matter is sent for mediation, if they have settled, it will be.
You see how the jurisdiction issue can be settled. Jurisdiction issue cannot be settled by parties.
So far as the grievances, their grievances is that we have not purchased the land variety from the concerned person. And although
So
we are in
the
possession of
divisional authority says that the Khasmal authority did not have the jurisdiction to allow or.
We have brought
So
on record.
therefore, under such circumstances, you can go before the competent authority. What's the big deal about it?
But we have brought on record the reply which we have received by RTI, which says pre-2000 era, when my order was allowed by Khasmal officer, the authority was with the Khasmal officer only, and post-2000 the circle officer has been given the power to pass the mutation order.
Prior to 2003,
Prior to 2000. Prior to 2000, the power.
When was the circle officer had passed the order?
17/7/1989.
89. Where is that information under?
But that we have an instance by way of Annex 5, what you may see. आदेश दिनांक 20/7/2000 को आयोजित प्रमंडलीय समन्वय समिति की बैठक में आयुक्त प्रमंडल हजारीबाग द्वारा दिए गए
कहाँ पे आप फाइल किए हैं? Where is that?
Lordship Annex 5 page 41. Lordship may see the
5
order.
to the writ petition.
Lordship, order of the Ayukt Hazaribagh.
Page number 41. Okay, read it please.
दिनांक 20/7/2000 को आयोजित प्रमंडलीय समन्वय समिति की बैठक में आयुक्त उत्तरी प्रमंडल हजारीबाग द्वारा दिए गए निर्देश एवं आयुक्त सचिव के ज्ञापन स्वयं द्वारा प्राप्त कार्यवाही के अनुपालन में हजारीबाग शहरी क्षेत्र की रहती भूमि का दाखिल खारिज सामुदायिक प्रभाव से अंचल अधिकारी सदर हजारीबाग के द्वारा नियमानुसार निष्पादित किया जाएगा। हजारीबाग शहरी खास मुहिम के अंतर्गत गैर मंजिलवा खास आम केसर खाकेराज एवं लीज की भूमि का दाखिल खारिज अंचल अधिकारी शहर नहीं करेंगे। अंचल अधिकारी सदर हजारीबाग को निर्देशित किया जाता है कि खतियान एवं पंजी।
इसमें कहाँ लिखा है कि खासमहल अथॉरिटी को पहले जुरिस्डिक्शन था?
वो नहीं लिखा, बट 2000 से ही they have been given the power.
No.
After 2000, Khasmal authority has been given power. Prior to that, it is the circle.
It doesn't help you in any manner. You see, if you are, the point is that they say that he did not have the authority to pass an order of mutation. You go before the competent authority and get it done.
But the authority, they have also not considered the judgment passed by the competency
What?
board. But the lordship may kindly
No,
see
the point is that the authority will consider, who has got the authority to pass an order. He will consider. A person, an order which is without jurisdiction, even a positive, negative, any observation made therein is of no consequence.
But the revenue authorities cannot merely discard the judgment passed by the.
They have no. See, the order is that he did not have the jurisdiction to entertain.
That they are saying.
Simple. That they are saying it is very, very simple. What is the big deal about it? You go before the company. 2003 से क्या कर रहे हैं आप लोग इसमें? Story. Yes. कुछ भी नहीं है इसमें. आप चले जाइए सर्कल ऑफिसर के पास चले जाइए अपना म्यूटेशन करा लीजिए. इतना ही तो है. Who is for the state? Yes. What is your response to this order? This annexure? This annexure 5, what is your response? Annexure 5, para 14 का क्या response है आपके counter affidavit में? बताइए.
They have simply denied, given a statement that this one do not deny and dispute the statement. They have not denied it. The statement being para 5, 14 of the petition, which are based on record. But categorically denied others.
ये नोटिफिकेशन की टाइप कॉपी कहाँ से लाए हैं? तो कहीं का फोटो कॉपी भी नहीं है.
कॉपी में इसमें फाइल पर
कहाँ पर?
now record is the lordship so wants.
इस ऑर्डर से कहाँ लग रहा है कि prior to this date the
That has not been specifically mentioned.
It is not mentioned. Simply not mentioned. And this was the reason given by the appellate authority also.
Appellate authority
Also gave the same reason.
There's
Isn't it?
authority. Also
Where is the
gave
order of
reason.
the appellate authority?
Connection 3 page 33.
Yes, he also gave the same reason.
There's-
So the land is
But based on the
not a
inspection.
half mal land. Half mal land आता तो otherwise कैसा था? It is a rightly land. That में kindly see page 37.
The appellate authority has not specifically give their
Yes.
finding, but has said that on the basis of the inspection carried out by the concerned officer lordship, it appears lordship that it is not a class land.
Yes, it is not a khas mahal land.
It is rightly land.
Rayati land. And admittedly it is not a khas mahal land.
And
Isn't
it is
it?
not class land. we are also saying that prior to 2000, the power was vested in Khasmal officer.
But that is not the document to show that prior to 2000 the power was vested with the खासमहल officer to do the. ऐसा हम लोग अभी तक तो सुने नहीं है, पहली बार सुन रहे हैं. खासमहल अथॉरिटी खासमहल वाले जमीन का म्यूटेशन करते हैं, but not with respect to रैयती land. And we will just observe that fresh application will be considered afresh, and they will not be prejudiced by the impugned orders. But it is an admitted fact that it is not a खासमहल property. Correct? Heard the learned counsels appearing on behalf of the parties. District petition has been filed for the relief. कोई डिले नहीं होगा. यहाँ के ऑर्डर से बताइए कब आपको अप्लाई करना है. यू आर फॉर द प्राइवेट पार्टी. ओके, बताइए कब जाइएगा. इंस्ट्रक्शन आपको कोई जरूरत नहीं है. यहाँ से हो जाएगा तो कोई दिक्कत नहीं है. एंड आई विल से दैट द मैटर हैज रिमेन पेंडिंग ओवर हियर फॉर क्वाइट सम टाइम. और वैसे भी म्यूटेशन का टाइम बाद
कभी भी हो सकता है.
नहीं ऐसा नहीं होगा, ऐसा नहीं. देखिए, heard the learned counsel appearing on behalf of the parties. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the prayer for mutation, the petitioner is claiming property by virtue of a registered sale deed executed by the descendants of the recorded Rayyat. The application was allowed by the खासमहल officer by order dated 17/7/1989, but the order was set aside by the appellate authority by observing that the property is not खासमहल property, and the learned commissioner has dismissed the revision by observing that the खासमहल officer Hazaribagh, who was not even the competent authority vested with the power to mutate land, as the power was vested with the Anchal Adhikari, Sadar Anchal Hazaribagh. The learned counsel has referred to Annexure 5 and has submitted that the same revealed that by notification dated 22/8/2000, the circle officer was given the power to do the required mutation, and by the impugned order, and the order of mutation was passed on 17/7/1989. The learned counsel for the state has submitted that the Annexure 5 does not reveal that the खासमहल officer was to do the mutation in connection with Rayyati land also. And admittedly, the property is not a खासमहल property, but it is a Rayyati property, and therefore the impugned order does not call for any interference. He has submitted that there is no impediment on the part of the petitioner to approach the circle officer for mutation, which can be considered as per law. To this, the learned counsel for the petitioner has submitted that the circle officer, upon fresh application, may reject on ground of delay. After hearing the learned counsel for the parties, आपका भी नाम लिखते हैं. The learned counsel appearing on behalf of the private party has submitted that the petitioner may approach the circle officer for mutation.
There is no illegality.
He has submitted that there is no illegality in the impugned order. After hearing the learned counsel for the parties, and during the course of hearing, it remains undisputed that the property is not a खासमहल property. However, the order of mutation was passed by the Khasmail officer, which has been set aside by the appellate authority and confirmed by the appellate order has been confirmed by the revision authority, who has also observed that the Khasmail officer did not have the jurisdiction to pass the order of mutation. So far as Annexure 5 is concerned, the same does not reveal that the Khasmail officer had the power to pass order of mutation in connection with Rayati property also. This court is of the view that the impugned order, whereby it has been held that the Khasmail officer did not have the power to, was not vested with the power to mutate the land involved in this case, does not call for any interference, as no notification has been brought on record by the petitioner by which the Khasmail officer was empowered to do mutation at the relevant point of time. However, it is certainly open to the petitioner to approach the circle officer for the purposes of mutation, as the impugned order has been primarily passed on the point of jurisdiction of the Khasmail officer to entertain an application for mutation with respect to the property which is admittedly not a Khasmail property. The fact also remains that the matter has remained pending before this court since 28/2/2003 and was admitted for final hearing.
One of the documents which we have gotten record by your secretary, but which have been obtained by RTM. So, that the area, the village, where the land is situated, is part of the Khasmail region, Jharkhand, Hazaribagh Khasmail.
Village, land is not.
Village land
Village is different.
कहाँ से आपकी नया कहानी आपके पिटीशन में कहीं लिखा है इट इज अ खासमहल प्रॉपर्टी?
But
आप अपना रैयती प्रॉपर्टी को खासमहल बताना चाहते हैं?
नहीं, इसमें सप्लीमेंट्री से क्या प्रॉब्लम है?
सप्लीमेंट्री से क्या होगा? You just tell me from the writ petition that it is not a खासमहल, it is a खासमहल property. It is not your case. सेल डीड लगाए हैं आप अपना?
सेल डीड इज नॉट
डिक्री लगा है, डिक्री भी जो है वो
डिक्री में क्या ही होगा लिखा हुआ? आपके सेल डीड पे होगा ना नेचर ऑफ प्रॉपर्टी. डिक्री कहाँ लगाया दिखाइए?
डिक्री में ऑल द लॉर्डशिप्स हैव annexed in annexure 2 lordship case 24. The suit which was filed by the private respondent, father of the private respondent. Lordship schedule C में ये mentioned है page number 29.
Description of Rayati land. ठीक है? In such circumstances, the apprehension of the petitioner that the application for mutation may not be entertained by the circle officer after a long lapse of time is unfounded. हो गया काम आपका बन गया? It is further observed that if any application for mutation is filed by the petitioner before the concerned circle officer, he shall decide the application in accordance with law without being influenced by any observation on the merit of the case as mentioned in one or the other orders passed by the authority, as the authority who has entertained the application and passed the order of mutation had no jurisdiction to entertain such an application.
टाइम में भी फ्रेम 6 महीने के बाद फाइल करेंगे, 1 साल के बाद करेंगे।
आपको टाइम चाहिए?
टाइम फ्रेम कर दो।
Should we fix the time?
Within 3 months? Within 3 months.
Item 2, WBC 4301 of 2003.
Case.
You are for whom?
Not private respondent, not 585C.
Yes, so.
Not I'm just saying what will be taken. They are.
Why?
Not we
You are for
have.
the petitioner.
Yes, I am for the petition.
What is the matter?
The matter arises out of an application made under section 46(4) of the Chhotakut Tenancy Act.
46(4) is seeking
Yes.
permission.
See, not permission exactly, that annulling a transfer which was in contravention of the provisions. There is a prohibition under the Act, and we made an application that despite the prohibition, the transfer has been made or the transaction has been made, and so we made an application for restoration of the land. That application was allowed long back in the original proceedings by the ACR officer. Then they moved in appeal. The appeal
Now
was,
tell us, what is the difference between 46(4) and 71A?
there is 46(4) was in the initial act.
Which is it?
In the original act, 46(4) was in the original act, 1908 act. It prescribed for a restriction with regard to transfer of the properties which are recorded in the Khatiyan in the name of tribals or the scheduled castes or the backward community was also there of all those. And there was a limited proviso, exception was there, that there can be legal transaction by permission within the same Thane area. This was the original act. Now 1969, there was a regulation, scheduled area regulation 1969. That regulation was framed under the power of making regulation vested by this 1900 original act. That regulation brought two things important. One was that made an amendment in the Code of Civil Procedure Order 1, stipulating that in all proceedings,
That's right.
uh,
Deputy Commissioner
yes.
is a party, then
Yes, yes.
section 65 also amended,
yes,
30 years limitation.
yes, Limitation Act in there, state amendments were made. And thereafter 71A was also incorporated, thereby giving the power to the Deputy Commissioner for restoring a land belonging to the original tribal
So
resident.
that power was already there.
That was already there.
Then
That was-
why 71A was it?
This was, the Deputy Commissioner was specifically vested with this power.
Okay. Under section 46, who is
46
the authority who can annul?
I am just reading the language that will be clear for us. 46, I am just tracing the chapter 7. Chapter 7, the heading is it is after the rejectment.
46(4).
Yes, and before that, this entire chapter relates to land exempted from chapter 4 and 6. And then 43 is part to acquire. And then chapter 8 comes lease and transfer of holding and use. And then 46 is the restrictions on transfer of their right by Raya. No transfer by a Raya of his right in his holding or any portion thereof by mortgage or lease for any period except to implied which exceeds or might in possible event exceed 5 years. A restriction put on mortgage or lease, and then second is about the permanent transfer by sale, gift or any other contract or agreement, 46A. And then the proviso is there, provided that Raya will enter into a with regard to the pledging of my mortgage, Bhugat Banda. And then the provisos are there, 46(1), the two provisos are there about previous sanction for transfer. And then B is with regard to scheduled caste or backward classes, occupancy Raya. And then 46(2).
You see, section 46 finds its place in 71A also.
Yes.
What is the difference?
The 46 is the basic section, that the statute mandates about restriction. It provides restriction that there will be no transfer, and there are some exceptions so far as making of mortgage. Only Bhugat Banda mortgage will be permissible, and then mortgage or lease for a period not exceeding 5 years. These are the basic inherent conditions in the statute, in the law 46. And then 71A, if we come to 71A, which has been incorporated in the year 1969, it says it gives the power to restore. It is basically the power vested to
Same power is there with the deputy commissioner under section 46(4)A.
the
Same power is there.
Yes, 46(4)A.
Yes.
That was simultaneously. This was simultaneously inserted by the amendment 46(4)A.
So I just want to know.
May I
That's why 71A does not cover the situation.
71A, there is one thing. 46(4)A says a limitation of 12 years. 46(4)A, the proviso says, and 71A says at any point of time.
So therefore, this limitation is defeated.
The limitation is not defeated.
Right.
There your lordships has interpreted at any point of time. That means to mean a reasonable time.
Reasonable time.
In the case
So
of
in all the cases, it is coming 30 years. Generally.
Yes.
Right?
Ah.
So this particular period of limitation prescribed under section 46(4) capital A is nullified.
And now
It
now
only
so-
provides 12 years.
Now if according to reading of this 46(4)A, if an application is under 46(4)A, and then in such case it has to be within a period of.
I don't understand. The same consequences, the same thing is there in 71A and 46 also.
Because the purpose of the lawmakers was here. The language is like this 46(4)A. I'm just reading it for myself. The deputy commissioner may of his own motion, like 71A, or on an application filed before him by an occupancy rider who is a member of scheduled tribes, for annulling the transfer on the ground that the transfer was made in contravention of clause A of the second proviso to subsection 1, hold an inquiry in the prescribed manner to determine if the transfer has been made in contravention of the second proviso to
भाई
subsection
रीड
1.
करने से क्या होगा, आप हमको
नहीं,
बताइए.
इसमें ये जो है specifically deals with the situation where the occupancy riot is a tribal, and then where there is a transfer, and the transfer is for the purpose of defeating some kind of transfer between.
Same is the thing in 71.
71A, there it is not
Yes.
not restricted to scheduled tribes merely. 71A.
71A is restricted to scheduled tribe.
If a tenant comes of the unlawfully transferred, then deputy commissioner belonging to a Raya or a Mundari Kutkatti or
Yes.
a Guyari,
Yes, who is a member of scheduled
who is a
tribe.
member of scheduled tribes.
So
These-
condition precedent of 71A is that he should be a member of scheduled tribe.
by fraudulent, here the language
But
has
that's
taken,
okay.
has taken
This
place
is
in.
too academic, you forget it. You are not able to explain. You just tell us what is your case.
Yeah.
समझने तो दीजिए ना इनका क्या केस है. What is your case?
Yes, we have made an application saying that this is our Rayati land,
Okay.
and there has been a
You are the,
transaction.
you are the recorded Rayat.
Yes, we have the recorded record. That is undisputed.
Okay.
We are the recorded here. Then we made the application, and that application was considered, and it was allowed.
Application seeking transfer.
Application seeking annulling the transfer for our possession.
Whom did you transfer? Annulling the transfer means that there was a permission granted by the deputy
No
commissioner
permission
for transfer.
was granted.
Okay.
Because if there
Who
was
transferred whom?
they made a claim on basis of a baji dawala. That is a deed, they say, that by which we were given by the land at the time of the ex-landlord. But no such document was brought on record, and then their main case when we filed the application was that they relied upon a compromise decree in a title suit.
When?
That
When is
was,
the date of compromise?
that was in the year 1967. That compromise decree, it has already been held that there is a bar of suits in cases of Chotapur Tenancy Act, and a compromise decree.
Already been held मत बताइए, judgment दिखाइए.
Please, I've got that is honorable court judgment. This is Keso South case. It has been held to be dispossession by fraudulent method.
You read the impugned order.
And this order has been passed on remand of the matter by this honorable court.
Where is the order of remand?
That is page 30. Page 43. Annexure 5, page 43. Paragraph.
You read it. Para 2.
Yes. By reasons of the aforementioned orders, the said respondents, in perpetual exercise of their rights conferred to them under section 46(4)(a) of the Chotapur Tenancy Act, directed that the land in question be restored in favor of the respondent number 3 to 9. As this writ petition is to be disposed of.
You were the writ petitioner in this case.
We were the respondents in this writ petition. The present respondents were the writ petitioner.
Okay. The writ application.
As this writ petition is to be disposed of on a short question, paragraph 3, the facts of the case need not be stated. From a perusal of the order passed by the Commissioner, North Chotapur Division, Hazaribagh, as contained in Annexure 8 to the writ application, it appears that he has not applied his independent right with regard to the point raised before him, and he merely relied on the judgments of the Deputy Collector, Land Reforms Hazaribagh, and the Deputy Commissioner Hazaribagh, without anyone specifying the reasons as to how the said finding arrived at by the Land Reforms Deputy Collector and the Deputy Commissioner Hazaribagh are correct.
Previously, the order was in your favor.
Yes. And the order.
Then thereafter, the fresh order.
Yes, fresh order which has been passed.
Page 51.
That is Annexure 8.
Page 50.
Page 49. Starting from page 49. 8/9/2002.
This was the order which was impugned
Yes.
in the earlier writ petition also.
No, earlier writ petition, that was the order passed in the previous proceedings. In the previous revision,
Now
five-
this, the commissioner is entertaining the revision application
yes,
and this is the last order.
this is the last order which is under challenge in this rate petition.
Okay.
The previous order which was found to be non-result, that is at annexure 2. Page number 35.
And you are the person who was seeking restoration.
Yes.
Please read.
This revision petition, which was earlier disposed of by order dated 21/7/1980 in Mela revision number 107/78, is again being considered in compliance of Honorable High Court. Hence, order dated 29/7/87 in CWS so and so. This land restoration revision is against the order passed by Deputy Commissioner Mediation in restoration appeal number so and so. The case of the petition brief is that on the petition upon Basho or others, ancestors of the opposite party, we were the opposite party in these proceedings. A restoration proceeding number 540 of 74 was initiated with respect to land under Khata number 163, plot 10, area 1.16 acres in village cantonment, and under Khata 142, plot 3181, area 1.13 acres in village Kodra, Sagar, Jharkhand, under section 46(4)A of the Tenancy Act and the Court of Land Reform Deputy Collector of Jharkhand. The Deputy Collector of hearing both the parties came to the conclusion that non-tribal petitioner here failed to prove that his land falls in municipal area, and secondly, the period of disposition is less than 12 years. And so, by order dated 27/75, he ordered to restore the land in dispute in favor of tribal office. Against this order, petitioner.
Tribal OPs, you are not the petitioner before the commissioner?
No, it was petitioner were the non-tribals
Non-
who were petitioner in the writ petition, previous writ petition.
Okay. Yes, please continue.
In revision case number, the petitioner being agreed with these two orders, the petitioner being agreed with these two orders moved before Divisional Commissioner, North Chhotapuर Division, Delhi, who also obtained the restoration by order dated 21 July 1980 in revision case number 107 of 78. Subsequently, the petitioner filed revision case number 243 of 80 in the Court of Member Board of Revenue, who also confirmed the order of the lower courts by an order dated 27/2/82. Eventually, the petitioner filed a writ petition before Patna Court, Ranchi Bank, bearing number so and so, by order dated 29/7/87, quashed all the orders passed by the courts, including the court, this court, and Member Board of Revenue, be set aside, and the case be remanded to this court to decide the case with independent mind, appraised in accordance with law. So this case has been admitted and is being considered on merit after hearing both the parties.
You see, not all the orders were set aside, only one.
Only the
order was set aside.
commissioner's
Only the
order-
commissioner's order was set aside,
Yes.
not all the
No,
orders.
not all the orders.
This is the wrong recording.
Only the commissioner's order was set aside and therefore remitted to the commissioner, holding
That's
that the commissioner has.
Okay, proceed.
During the arguments, the learned counsel for the tribal OPs had raised one issue, that lower court's record of the Deputy Commissioner land reform is necessary for the decision of this case, as some important papers are available on that record number so and so. This record was called for from DCLR by letter number so and so, dated 16/8/2002 and 26/8/2002, but the record has not been received as yet. The DCLR Jharkhand, in reference to these letters, to those letters of this court, has sent his report by letter number so and so, stating therein that the said record is 28 years old, which has not been placed either in the court or in the recording. The then bench clerk has retired and is probably died for now, so he is unable in sending the case record to this court, and as it is not recorded, to be disclosed in the record. It is relevant to mention here that the Council of the OP does not mention any document which was available on the said case record, and without that paper, how it is going to affect the OP's case adversely. The certified copy of the order of the DCLR is available on the lower court record of the Deputy Commissioner. In my view, the lower court record of the DCLR will not affect the merit of the case. Therefore, this case has been decided on the arguments advanced on the ruling cited by the contesting party as well as the matter is available in view of the remand order of the Honorable High Court. This court has to apply its independent mind without relying upon whatsoever has been observed by the different courts. So far, since the case is going for a considerable long period and the concerned lower court records have traveled to several destinations, it will be an arduous task to trace the original report and the remand order of the Honorable High Court be kept in abeyance indefinitely, which may attract the provisions of the contempt of court proceedings. Accordingly, this case has been decided with reliance upon the materials available and on the basis of arguments advanced. The brief contentions of the petitioners are as under. Number one, they purchased the land in dispute from the tribal office due to inabundance of law in 1962 through registered deed of Bajidawa dated 21/4/62 and gave possession to the petitioner in lieu of a consideration money. Copy of Bajidawa is annexed. Later in the year 1960, the tribal office tried to dispute the Bajidawa and hence the petitioner filed title suit number 1081 of 1960 in the court of Munsef, Hajaripur. Which was decreed in favor of the petitioner on the basis of compromise petition filed by the tribal tenants, stating therein that they had sold the said land in 1940 and the petitioner has possession over the same and they had no concern with the land in dispute whatsoever. The further plea of the petitioner is that the said land falls within the notified limits of the Hajaripur municipal area under ward number 1 and the transactions are prior to 1979 when section 46 was not prevalent in the area and therefore this transaction is neither illegal nor void, which cannot be annulled and the land in dispute cannot be restored to the tribal tenant as the very provision of section 46(4)(a) does not apply in this case. The counsel for the petitioner further argued that actually the petitioner had purchased the land in early beginning of the last century when permission was not at all required due to wrong entry in cadastral survey. The land became tribal land in terms of the records of right, but petitioner remained in peaceful cultivating position in the year 1962. Who solved this dispute? Registered Bajidawa was executed with an intention to resolve the issue once for all, and later it was confirmed by the decree in title suit 1081 of 66. Therefore, when tribal office filed petition for restoration of the land in dispute in 1974, it was dispossession for more than 13 years if counted from date of registered instrument. It is also said that the court below deliberately denied this facts on record and also did not consider that the said land falls under the limits of notified municipal area where CNT Act does not apply. The counsel appearing on behalf of the petitioner filed various rulings in 1988 and argued that section 46(4)(a) is not applicable in this case as the restoration petition is not maintainable being bad by law of limitations and restoration under the provisions of section 46 do not apply municipal areas. The counsel for the tribal office filed written argument will describe the case at length. He mentioned that Honorable High Court had remanded the case on 29/7/87, but the petitioner approached the court of commissioner after lapse of long time. He further submitted that restoration ordered by the DCLR and its confirmation by the additional collector Hajaripur and the commissioner Hajaripur and also by the member board of revenue. It has further been stated that tribal office are in continuous possession after it was restored to them in 1975. He also stated that Hajaripur municipality was constituted under the Bengal Municipal Act 1884. He also argued that under section 46(3), pollution title suits are barred in the same year. He referred to a ruling reported in so that such compromise decree in title suit against a tribal tenant cannot be given effect to. The council figured that petitioner be restricted from defeating the purpose of the provisions of law which has been enacted to safeguard the interest of weaker sections of the society, which include the tribal. The DT appearing on mistake submitted that Bajidawa has no meaning as the law on this matter is very clear. It neither creates nor any right nor extinguishes any. In the light of whatever has been stated and discussed in the foregoing paragraphs, it transparent that the case history in the listed case is long and checkered. Many facts have been stated on behalf of the contesting party which cannot be proved by record, as no reliable evidence on that account is available. Though it is very clear that in the eyes of law, deed of relinquishment, either registered or sadar, carries no meaning as a private tenant is quite liable to be won over by different means of coercive methods and however it is true from record that the tribals is disposed on the basis of decree of civil court by the process of court. But a registered document registered more than 25 years cannot be disbelieved and cannot be ignored by a revenue court when the same has been accepted by a competent court of civil jurisdiction. It is also a matter of concern that a land in dispute in this case shows within the upper limits of the Hyderabad municipality, municipal town, where law in terms of section 46 and section 71 of CNT Act do not apply. It is also clear beyond all reasonable doubt that no part of Majority district is notified under the Schedule Area Regulation Act, and hence the law of limitation in terms of disposition of private tenant will prevail. In view of the above restoration petition filed by tribal tenant is barred by limitation and not maintainable, since all the successive courts have affirmed the order passed by December, the fate of all.
So the property is not covered by Schedule Area Regulation Act.
No, it will be covered. The Schedule Area Regulation Act applies to municipal area.
No, this say that Hazaribagh area does not.
No, it is covered.
It is clear beyond all reasonable doubt that no part of Hazaribagh district is notified under Schedule Area Regulation Act. Tell me which is that notification? He is writing that there is no part of Hazaribagh area is notified under Schedule Area Regulation Act.
The Act itself says that it shall apply to municipal areas also.
म्युनिसिपल एरिया का बात ही नहीं कर रहे हैं, हजारीबाग दिखाइए. शो मी हजारीबाग.
I am just placing section 1, short title and extent of this act. Just after the preamble, the preliminary portion of the statute,
Yes.
this act may be called the Short Tenancy Act. It extends to. Then this has been notified. It extends to the North Shotnagpur, the South Shotnagpur and Palamu divisions, including the areas or parts of the areas which have been constituted into a municipality or a notified area committee under the Bihar and Odisha Municipal Act, or which are within a canton. So it is extends to North Shotnagpur.
ये भी बाद में notification होके हुआ है.
This is
This is 1992 notification.
with effect from May 3, 1992.
Yes, so
May 3, 1992.
all the transactions are prior to that.
Here, the transactions which are relied, this is being said for the purpose of maintenance. That transaction which is relied, that is the same registered relinquishment deed, the Bajidawala, which is said, which is relied.
What is the date?
That date is 1962. That is 1962.
So how do you show me that this act, this schedule area regulation applies to this area?
So far
लिखे हैं क्या आप अपने read petition में that it applies to this area? Show me that it applies to this area. It does not. You see, you are in writ jurisdiction. So, this finding, have you assailed this finding? But if you are not able to demonstrate that it applies to Hazaribagh area, there has to be a full stop to your
prior to
argument.
1992.
नहीं, ऐसा नहीं लिखा है ना prior to 1979. It says that it does not apply. It is not saying that it is prior to 1979 it did not apply.
So far as the act, now it has been said to be apply, said to apply.
कहाँ से बोल रहे हैं?
ये यहाँ से it extends to the North Shotnagpur.
We do not know हजारीबाग कौन से डिस्ट्रिक्ट में कौन से एरिया में पड़ता
It
है.
falls within North Shotnagpur.
I do not know.
It is the commissionary of the.
And that too in 1992, no? What will happen to those transactions which have taken place much prior to that? 1992 से 30 years पहले का transaction का बात कर रहे हैं हम लोग. And this is an application under section 46 where there is a limitation of 12 years. So, it is in village cantonment. This property is in village cantonment. You just see page number 54. Yes. Yes. So what case do you have? Nothing. अब इनको टाइम चाहिए.
Do counter file किया हुआ है. The cantonment area is not. Already has already had different orders also regarding the cantonment area that I have already got. At that limit also.
Where is that judge? फाइल खोलिएगा नहीं, खाली टाइम मांगिएगा.
फाइल कौन क्या है?
बहुत अच्छे से. हाँ?
कोई engage किए हुए थे इसमें?
कोई एंगेज का जीतने के लिए क्या एंगेज करना. हो सकता है कल तक हम कुछ ज्यादा पढ़ लें, आपके अगेंस्ट में सोचने लग जाए.
Already relied on the full bench, 5 judges bench of the Honorable Patna Court in this particular matter.
ये क्या हम कब पास किए थे? 2018 में.
Yes.
जजमेंट कंफर्म हो गया.
Yes, no, that I have checked, no, that has not been checked.
नॉट बीन चेंज्ड. वेरी गुड. ये कैंटोनमेंट से रिलेटेड है.
Yes, cantonment and that not even unregistered document was there. But in my case, not 62 Baridawa is not the registered document. For collateral purpose, that can be used. That can not infer that 46 4A, that is not 12 year of limitation is there. Registered document is not 62, and they have admittedly not applied for this not in year 1975, 76. That means after 13 years. That amendment not
बताइए. It's a cantonment area. CNT Act is not applicable.
On that issue, we cannot have a. So that part is concerned.
So that is the only part. You see, under 227, either jurisdictional error or perversity. So if the property is falling under cantonment area, then how this section will be applicable? बताइए.
Because in such situation, we may not assert the action to be in violation of section 46.
Yes, you cannot. You cannot assail it. Once you cannot assail it, the matter ends. The entire proceeding under section 46 4
in such case, our application itself would be not.
was not maintainable.
That's it.
falling in cantonment area, no? It is falling in the same area.
Yes, cantonment area. Later on, it was modified also, that order was modified, and it was then already written not actually quota wherein it should be actually be cantonment.
Yes.
Order was modified.
That's all.
May I just pray one thing, so far as that judgment on the issue of containment area.
नहीं आप हमको बताइए ना, you forget that. You just tell me that how this is applicable to this area. Because whatever
It is true, if we cannot show that we are falling within the purview of the CMT Act,
Yes.
we cannot make out a case.
you cannot, and that is the main reason for passing the order. And the amendment that you are mentioning is of the year 1992.
It is inserted in the 1992.
It is inserted in the year 1992. और which are within the cantonment area, वो भी लिखा हुआ है उसमें. That should be sufficient.
I think we could not supplement this, we cannot overcome this part. One submission we can advance that as on the date of passing of this order, it was applicable.
How do you see?
Because 92 this was inserted in the statute book, that 92 the act will be applicable in those areas. So on the date when this order was passed 2002, on that day this law was applicable in that area.
Then it is out of the cantonment area. It also says that even for cantonment area it is not or within, which are within the cantonment area. Section 1 subsection 2.
So by subsection 1 to by this amendment it was extended to all areas including cantonment area.
So what is the you see, initially he passed an order, it is not applicable within Hazaribagh municipality, right? And then he says that it falls in the cantonment area also. So even if it does not fall within the municipality, even if we say that okay, cantonment, you forget it because it was introduced in 1992, right? Then also it is falling within the municipality of Hazaribagh. Then how will you use this particular provision for an area falling within the municipality of Hazaribagh? So you have to show that CNT Act was applicable to the areas which was falling within the municipal area of Hazaribagh. Even that you are not able to show.
Before 92 we cannot 92 since 92 it has fallen. Before 92 it was not applicable.
It is not a case that it will extend to all the areas in Jharkhand. That is not the case.
The language extends to the North Chodnagpur, the South Chodnagpur and Palamu divisions, including the areas. It was already from before. It has been extended to North Chodnagpur, South Chodnagpur and Palamu division.
Yes.
This was already there, included in the original statute.
We do not know what is the original statute. It is for you to say.
Because this is by way of this insertion is by of this amendment.
What was the pre-amended provision? Pre-amended provision also must have been there. म्युनिसिपल एरिया में रैयत लोग कहाँ से आएंगे? रैयत will not be available in municipal area.
So far as municipal area also there will be riots, because the riots are there whose names are in the Khatiyas.
No, riots, no, merely because the name is there in the
And the
Khatiyas.
Chodnagpur Tenancy Act defines.
No, you see, the crux of the matter is that the court has, the authority has held that it is not applicable. You show me it is applicable. It is for you to show and demonstrate that it is applicable. We cannot, you see, unless you show that it is applicable, nothing, you cannot argue, you cannot move a step ahead. There is nothing on record to show that it is applicable.
No, of course, that is.
That's it. The state has filed counter?
Yes.
Where is the state's counter? Sorry? What is their stand in the counter affidavit? You filed it in 2011.
They have accepted not that Venkat Balidawa was there in 1962. The deed of 1912, my thinking was of 1966 that they have admitted. They have also taken note in favor of that 12 years left, more than 12 years back already. But they have taken all this down. Even the position.
Why was the amendment made? Why was the amendment made?
Not sense, not one of the respondents, but respondent 5 has died. And they are not.
So amended petition was filed because of that. Where is your counter affidavit?
file counter number 18/7/2000. Counter IFNX number the registered Padidava.
So according to you, they were dispossessed in 1997.
But there were
Sorry, 1967.
according to
Bajinama is
62 registered.
And what is Bajinama?
Padidava note
That is deed of relinquishment,
deed of relinquishment.
which they say that earlier it was transferred, but there was no document, so this deed of relinquishment was executed.
And this was the suit. This was dated.
But
1960s. The decree is dated 20th April 1967. The compromise.
21/4/1967.
Seven.
And this deed is dated
deed is 21/4/1962.
21/4/1962. The relinquishment deed was already there,
Yes.
much prior to
First must have.
the compromise decree.
Yes.
And then the application for restoration was filed when?
1975.
Where is the order?
The first order is not there on record, which was not received. The second order is there, that is annexure 2 at page 31. The second order is there. Appeal.
This was of 1974 edition, first restoration.
This was filed under section 46(4),
Yes.
1974.
540 of 1974.
540,
Yes,
1974,
That order is not on record.
which was decided on 2/7/1975.
This case number is 550 of 1975.
From where do you get this?
As mentioned in page 32, there are page 32, that is the appeal against that order.
That's right.
And in there the order.
No, case number is not mentioned, date of order is mentioned.
Case number is also mentioned at page
Where?
32, running page 32.
Yes, running page 32.
Annexure 2, page 32.
Yes.
This is an appeal against the order of the deputy collector, Sri so and so, passed on 2/7/1975.
Okay.
Is
In case number
550 of 1975. And whereas the case number is mentioned in the present order is 540 or 74.
Anyways, there is a mismatch of 1 year. But it was decided on
The date is
2/7/1975.
2/7/1975.
This was also decided against you. This one?
That
Revenue appeal?
No, this was the order of restoration was appealed. Order of restoration was appealed. From that analogy only, that the compromise decree is not permissible, on that analogy it has been allowed, and also relying on the report that they came in possession after 1967. Prior to that, they were not in possession. Upon the report of the circle officer. And so it was within 12 years.
And this 46(4) was introduced when? 46(4)(a).
1981.
This was inserted in by the 1975 Amendment Act.
Where is it mentioned in the book?
Here in the book itself, corresponding to that notification, inserted by section 3C bit. There is a reference of the Jharkhand Tenancy Amendment Act in the noting. Jharkhand Tenancy Amendment Act 1975, Bihar Act 11 of 1976.
4A was inserted only thereafter. I will simply write you have not been able to show anything as to how this act is applicable. That is the only thing I can write. Yes, madam. It is your order and the act is not applicable.
Yes, as per the order that has been taken into account that CNT is not applicable to the municipal area.
There is one notification which the honorable candidate knows, which says about the Governor General's CSO.
It is in this book.
Yes, I think it used to also there.
Page number. Page number says
171.
So आप क्या बोल रहे हैं? What do you want to say from this?
That from that notification it appears that except in 4 sections, other sections have been made applicable in the district of Chhatapur as it appears from that notification.
In the district of Chotanagpur, no.
In the district of Hazaribagh, it says. That's first one. Second one is for district of Manbhum as at that point it was there.
The point is whether it is applicable to municipal area and whether it is applicable to cantonment. Right? So from where do I get this?
Because application in the district of Hazaribagh,
ये notification से थोड़ी हो जाएगा.
because this was an assented notification issued by at that point of time the then His Excellency the Viceroy and Governor General of, and published in the Gazette. This was a Gazette notification made on 5/11/1920. There is exception of 3 sections, 18, 33, 38, which are not relevant for our purpose for the present litigation.
Unless you show it from the main section, how do we get it? You have to show it from the main section, no? That it is applicable, and it is applicable in municipal area also.
We have to know if this matter is taken up tomorrow as the first case, we will just find out further on this amendment act's effect, this notification's effect, which was gazetted and published with the Senate. The implement order is based is only for the reason that it is not applicable, and the further limitation has also been set. If it is not applicable, there is no question of limitation itself.
No, if it is not applicable,
Then there is no question for
no.
limitation.
Otherwise also,
Yes.
your application is otherwise also much belated under section 46(4).
No, there 1967 they came into possession. That is a report of the circle officer recorded in the previous order of the Deputy Commissioner. 1967, and the application was made in there 1975. So
No,
it was,
they came in possession in by way of registered document.
no, there is a report that they came in 1967.
What will
After
prevail?
that decree, that is a finding in the Deputy Commissioner's order itself, which is not disputed. Perusal of the order of learned lower court shows that the Anchal Adhikari, I am reading from the order of the Deputy Commissioner, Anchal Adhikari has also reported that the appellants came in a possession only after getting the decree in title suit number 1081 of 66, passed in 67. Thus, the petition filed in the lower court was within 12 years and hence cannot be sent to the time board. Taking 60 from 60.
Where are you reading this?
This is running page 34. Running page 34, operating portion of the order of the Deputy Commissioner. In the land restoration appeal.
34.
Yes.
The commissioner has also recorded this finding that you came in possession on such and such date.
In the previous round,
Yes. You forget about the previous order. Now you refer to the new order.
new order there is no finding on that.
Finding that has been given for that.
New order there is no finding on so far as with respect to that report. Because if
No, but
what has also been observed by this court, if
finding of fact must be there, no, when you were dispossessed, isn't it? It must be there in the impugned order also.
that is there in the deputy commissioner's order also.
See, if the compromise decree is a collusive decree, right? Then neither title nor possession can be relied upon such a decree.
And,
Isn't
yes,
it?
and the actual report was that on that basis then they came into possession. That is the
What was your case? When were you dispossessed, according to you?
our case is that we were dispossessed.
Yes. When? When were you dispossessed? Now at least this fact is not in dispute that it is within the cantonment area.
Now that has come, that correction has also been made.
That correction has also been done, right? So you have to bring the Act of 1920 to say as to whether this was applicable to cantonment area or not.
Or the original 1-2, because 1-2 as mentioned in the statutes, it appears that it was applicable to cantonment. It extends to,
No,
or which are within the cantonment.
no, this, as I remember, you have seen somewhere that this act was not applicable to cantonment even in the year 1920, but only the area was extended. And the entire cantonment, you see, the entire cantonment area was excluded. Even in the act as it originally stood, the entire cantonment area was excluded. Because even the Ramgarh cantonment had come only in the year 1941. So you cannot say that this particular act was introduced only to this effect, which have been constituted into a municipality or a notified area committee under the Bihar and Odisha Municipal Act 1922, or which are within the cantonment. You get the notification. I'll pass the order tomorrow. Okay?
Yes.
Is that okay? That notification will clinch the issue.
Yes.
Heard the learned counsel for the parties. The crux of the dispute involved in this case is as to whether Chotanagpur Tenancy Act applies to the area involved in this case. The commissioner in the impugned order initially held that it is not applicable to municipal area. However, subsequently it was clarified that the property involved in this case is falling under cantonment, village cantonment. The learned counsel for the petitioner has not been able to show any material on the basis of which it could be said that the Chotanagpur Tenancy Act was applicable to the area in which the property is situated. Although one of the main bases of the order passed by the learned commissioner was that the act is not applicable. आप भी खोजिए मैडम, ये जो है ना 1920 का अनअमेंडेड एक्ट, उसमें मिलेगा. Now there is a very, you see, initially when the commissioner holds that it is not applicable to municipal area, right? He takes whether it is applicable to municipal area or not. Subsequently, he changes the nature of land itself and says that it is cantonment area. Now we do not know whether this cantonment is falling in the municipal area or it is not falling in the municipal area. We are not aware. So the original act is required to be seen. Village cantonment, we do not know whether it is falling in municipal area or not. There is no material to say. So the commissioner has actually not examined as to whether the act was applicable to the cantonment area, to the village cantonment. He should have examined, no? As to whether the act is applicable to the village cantonment or not. पहले तो पास कर दिया municipal area में.
Finding of
Not that particular, not that point was also raised before the original authority. It is subsequently, it is only an amendment since that has been mentioned. In the petition, those things have been mentioned. तो ओरिजिनल ऑर्डर से पहले भी हो रहा था, उसमें भी ये पॉइंट्स था.
Petition से नहीं होगा ना?
नहीं, वो ऑर्डर में भी जो ओरिजिनल ऑर्डर है उसमें भी कैंटोनमेंट के रिस्पेक्ट में पॉइंट्स रेज हुआ एंड दैट हैज बीन डेल्ट.
Original order मतलब the first order.
The order which is under challenge before this one.
order which is under challenge in this court, but the finding is that it is not applicable to the point that it is in the cantonment area was raised.
Then,
But the finding is that it is falling in municipal area.
That
The-
aspect has not been examined, Ladyship.
Yes, that aspect has not been examined.
Only finding has been given that clerical, due to clerical.
Yes. That aspect as to what will be the consequence of changing
even
the.
now, my lord, even now, my lord, on the sites, all the Lord rent receipts are being issued in favor of this prisoner, and Lord, all are in the village cantonment. It is already Lord recording in the Lord online portal also.
ये इन्हीं को दिखाना होगा, because they are assailing the order. It is they who has to demonstrate. Is there anything he wants to show?
No, that is a rent receipt. Our name is also there on the record of it.
That is a separate. Post this case for further hearing.
Lord, at page 37 of the counter, that Lord rent receipt. which-
That rent receipt will not decide anything.
Lord, that says Lord it is within cantonment. That is-
Now the fact that it is within cantonment area is not in dispute. Now whether this cantonment area is within municipal area is something which is not available on the record, isn't it? Over and above the fact that your cutoff date is 1962 and their cutoff date is 1967. And no finding has been recorded by the learned commissioner as to what is the date of possession.
Lord,
What is the oldest rent receipt you have?
I have Lord. and
When? What is the oldest rent receipt you have?
Lord,
Post 1967 or pre 1967?
390.
Where is
even,
it?
Even Lord, may I say Lord, that 1962 that is a registered Bajidawa. That means Lord that they have already relinquished their shares. That means in 1962 when they have already relinquished their share in 1962 Lord, by a registered document, meaning their my Lord. For a collateral purpose, we can assume Lord that for a collateral purpose that
We will
they-
not assume that they relinquished, they gave up their possession also.
even they are saying Lord that relinquished that Lord that is a registered document. It is not an unregistered Lord. And from 1962 to 60 Lord thereafter Lord 1975.
There is no allegation that that particular document was collusive.
Yes,
ऐसा तो कोई allegation नहीं है
नहीं.
that the transfer in the year 1962 to a registered document was collusive. Collusive किस पर है? Title suit पर है. But the transfer in the year 1962 was collusive. ऐसा कोई allegation तो है नहीं. Get hold of the notification. We have to make it clear. Okay. कल 2:15 सुनेंगे. First I will hear your case and then I will take up the Passover bail matters. Okay. हम देखे हैं notification, हमको याद है, but I am not able to really find out where it is. I will try and find out if I am able to. ये सर, ये 2 कॉपी दिए आप हमको. कौन करेंगे?
Item 3 WPC 5212 of 2003.
Yes, petitioner.
Yes, at the outset, and to give it, we have to file a supplementary affidavit, that is ready. And
For what? 2003 का matter में supplementary
Yes.
affidavit.
Yes,
Why do you want to file a supplementary affidavit?
and this is to bring on record a resolution of the board which set us the issue.
Which is the resolution of the board?
Petition will file it.
So you want to say that resolution of the board settles the issue in your
Yes,
favor?
yes, set us the issue. So I am simply praying for not today, I shall be bringing your.
कोई जरूरत नहीं है ना, आप ये रेजोल्यूशन दे रहे हैं, हम बोर्ड को बोल देते हैं आपको इस रेजोल्यूशन को कंसिडर करने के लिए, इसमें क्या है? हो जाएगा उसी से.
ठीक.
provided they feel that it is applicable. I will not say anything more.
Yes, it is applicable.
You are for the board? They are referring to some resolution, have you seen?
Leadership, I have seen, but I have asked for a copy leadership. I'm not gone completely through the resolution. And I have to take instructions from them also leadership. Whether it is applicable in their system.
आज सिर्फ नोट पूरे करने से it will be okay. कल इनको हम कॉपी दे देंगे और कमिंग वीक ट्यूसडे को सुन लिया जाए इसे 250.
क्या आपका ऑर्डर इम्प्यून है? कोई ऑर्डर की मैंडेमस मांग रहे हैं?
हाँ डिमांड
You are seeking mandamus?
यस ढेर सारा डिमांड था. आई हैव पेड फॉर प्रोसेसिंग ऑफ दोस डिमांड और अनेक्सर 8 सीरीज अनेक्सर 8 सीरीज अदर डिमांड
रिफंड भी मांग रहे हैं आप तो?
मतलब
रिफंड भी मांग रहे हैं?
हाँ रिफंड भी मांग रहे हैं. दैट वाज पेड इन अबंडेंट परसेंट और ये इनका इससे हिसाब करेंगे द रेजोल्यूशन दैट आई प्रपोज टू ब्रिंग ऑन रिकॉर्ड. उसके आधार पर हमको पैसा वापस मिलेगा. 45,000 the original petitioner had deposited with abundant caution to neutralize the dues of the board if any. I have also brought on record calculation as per me, that is annexation 10, and that calculation was made from the date of possession. Date of possession.
आपका डेट ऑफ पोजीशन क्या है?
Date of possession is 15/3/1989. Date of agreement is 2/7/1985. House was allotted on 28th September 1983, and I was directed to deposit rupees 10,000 for so that the agreement can be executed. That I deposited within 30 days. But since their house was not complete, they entered into an agreement with me on 2/7/1985, and as per that agreement, the installment was to be paid from August 1980, from next month of agreement. That was to be paid from August 1985. And the resolution that I propose to bring on record, it says, clause 3 may kindly be seen. Clause 3.
Yes. पढ़िए.
जिन आवंटियों का इकरारनामा पूर्ववर्ती बिहार राज्य आवास बोर्ड के समय संपादित हुआ है, उन आवंटियों को माननीय झारखंड उच्च न्यायालय सर्वोच्च न्यायालय द्वारा विभिन्न याचिकाओं में पारित आदेश के आलोक में इस पद्धति से इकरारनामा दैट इज हायर परचेज एग्रीमेंट डेटेड 2/7/1985 में निहित प्रावधान के तहत ही गणना किया जाए. आवंटियों को पावना राशि की सूचना दीजिए. और इनका जो डिमांड नोटिस है वो फ्लक्चुएट कर रहा है, कभी बढ़ रहा है कभी घट रहा है. I have paid for processing of that.
We have filed a supplementary leadership. Basically, we have mentioned that the substitution here leadership and petition will present their torture leadership and they receive the these regarding to that leadership. Whatever be the outstanding amount after the completion of the calculation leadership, they will be according to that release we will be executed.
Will you demand the outstanding in terms of this circular?
No leadership. They are taking on record right now leadership, but earlier they have filed a supplementary counter leadership in 2022 leadership.
Just not today we will. I will bring it on record. I shall be filing it tomorrow. Yesterday he obtained a copy. The substitute petitioner number 1 obtained a copy yesterday evening. He gave it to me, and I thought it proper to bring on.
You see, the point is that the order has been passed with respect to those cases where the demand has been quashed.
No.
Yes. See, जिन आवंटियों का इकरारनामा
इकरारनामा
यस बिहार राज्य आवास बोर्ड के समय संपादित हुआ है.
यस
उन आवंटियों को माननीय झारखंड उच्च न्यायालय सर्वोच्च न्यायालय द्वारा
हाँ
विभिन्न याचिकाओं में पारित आदेश के आलोक में इस पद्धति से इट इज मेड एप्लीकेबल टू ऑल द allottees.
Yes. Whose agreements were executed during the tenure of Hospital Bihar State Housing Board?
By virtue of this particular circular, you have not received any demand.
No. हमारा इस रिजोल्यूशन के आधार पर डिस्पोजल होने से उनको हमारा प्रेयर ये होगा कि वो डिमांड नोटिस को प्रेस करके उनको रिव्यू कर दिया जाए मैटर टू मेक ए फ्रेश कैलकुलेशन एज पर देयर ओन सर्कुलर and to communicate the calculation and the demand notice if any amount is still due, and if any amount comes still due, I shall pay and get the house transferred in my name.
Why are you seeking refund?
Excess that I put.
How excess? How is it excess?
As per my calculation. Kindly come to my supplementary affidavit dated 20th April 2011. 20th April 2011.
So you have deposited by way of abundant precaution.
Yes. And as per my calculation.
Because that was the demand of 45,000. They raised their demand of 45,000.
ये जमा करके उनका डिमांड घटते बढ़ते रहता था, उनका डिमांड घटते बढ़ते रहता था। ये हमारा जो वैसिंग हम प्ले किए हैं एक्सेलेंट सीरीज का, उसका रिजल्ट से ये आ जाएगा कि इनका डिमांड हमेशा घटते बढ़ते रहा है। और हमारे कैलकुलेशन के अनुसार से 45,243 रुपये हमारा एक्सेस है।
For the learned counsels appearing on behalf of the parties, the counsel for the petitioner has submitted that he will be satisfied if the respondent board is directed to consider the case of the petitioner in the light of their own circular as contained in Office Order number 05/R-27-2015/860 dated 27/4/2015. He submits that in order to enable them to give fresh calculation in terms of the said circular, the impugned demands in the writ petition may be quashed and set aside, and the matter be remitted to the Managing Director, Jharkhand State Housing Board, to pass appropriate orders. The learned counsel submits that he is ready to deposit whatever be the calculation made in terms of the aforesaid circular dated 27/4/2015. Yeah. The counsel for the respondent board has submitted that she will seek instructions as to whether the case of the petitioner can be considered in the light of the aforesaid circular. Circular का एक कॉपी उनको दे दीजिए, ठीक है? परसों, day after tomorrow. Post day after tomorrow, in the supplementary causes to be taken up at 215 first case. आप खाली इंस्ट्रक्शन दे दीजिए, अगर then I will quash the demand, नहीं तो डिमांड नहीं quash करेंगे तो कैसे होगा, है ना? And whatever payments have been made will be adjusted accordingly. In terms of that, ये वापस a copy of the circular has been produced before this court, which is kept on record. एक कॉपी यहाँ दे दीजिएगा सर.
Item 4, WPC 6569/2003.
Who is for the petitioner? Forceful dispossession. What is it? यहाँ आपको क्या डिसाइड करेंगे हम लोग? सूट
नहीं है,
फिर क्या डिसाइड?
एकदम एक ही पेज तो और कुछ देखना जरूरत नहीं है। यूनिवर्सिटी में काइंडली सी annexure
5
directly 12 और कोई चीज पर 12 and the report which is annexed at page 70.
12.
Yes.
Yes, tell me what is it?
12, there is a report which is by circle office it was forwarded. And what does the report say? संदेहास्पद जमाबंदी अभिगत में सो एंड सो चल रहे जमाबंदीदार का नाम केदारनाथ मित्तल. That was the original petitioner.
इलेक्शन
Now-
12 में ना पर्चा है इलेक्शन 12 में।
नहीं, ये तो हस्तांतरण का पर्चा का नेक्स्ट पेज।
नेक्स्ट पेज।
हाँ, ये रिपोर्ट का बेसिस में
हाँ।
फिर ये
ठीक है।
ये दिस इज द रेवेन्यू रिकॉर्ड ऑफ द स्टेट इटसेल्फ।
यस यस।
चल रहे जमाबंदीदार का नाम केदारनाथ मित्तल, he was the original petitioner, he died and has now been substituted.
यस।
Then ग्राम so and so, all these plot numbers are there. जमाबंदी कब से चल रहा है? 1955 से। पहला रसीद कब कटा? 1955। आखिरी रसीद कब कटा? 1957। And then जमाबंदी नियमित किया। So this was a case which was initiated for cancellation of Jamabandi on the ground that it was suspicious. Now why this proceeding was initiated? That may kindly be seen. It was initiated for the reason that now page annexure 11 may kindly be seen. Because annexure 11 says, I may be allowed to read one page. This is the order sheet of their own order sheet. It says उपायुक्त छत्रा द्वारा मौखिक रूप से निर्देश दिया गया कि पुलिस लाइन छत्रा के लिए लगभग 30 एकड़ सरकारी भूमि के हस्तांतरण का प्रस्ताव शीघ्र भेजा जाए। उनके द्वारा यह भी आवेदन दिया गया कि पुलिस लाइन छत्रा के लिए जो कृषि फार्म का प्रस्ताव सरकार को भेजा गया उस पर संबंधित विभाग द्वारा अनापत्ति नहीं दी जा रही है। फलस्वरूप पुलिस लाइन छत्रा हेतु नया प्रस्ताव देने हेतु आदेश दिया गया है। इस संबंध में नाउ with regard to some other land this no objection was not given by that concern. इस संबंध में उपायुक्त छत्रा एवं पुलिस अधीक्षक छत्रा के नेतृत्व में प्रस्तावित पुलिस लाइन स्थल का चयन छत्रा सो पर स्थित ग्राम किशुनपुर, ग्राम देवरिया में क्रमशः खाता नंबर इतना में 13 एकड़ and so all these are mentioned. Total 15.72 एकड़ का चयन किया गया। संबंधित हल्का कर्मचारी अंचल निरीक्षक एवं अंचल अमीन द्वारा को आदेश दिया जाता है कि पुलिस लाइन के हस्तांतरण हेतु प्रस्ताव अविलंब हम इस्तेहार प्रस्तुत करें। And then next page is the letter by which the land is transferred, which includes my land of 1.42 acre out of total 2.50. My land, state record itself shows that the Jamabandi is coming from 1955 itself. Last rent receipt had been issued till 1997. Undisputed. If the state would have said that no, if this was a state's property, I could have understood. Absolutely nothing on record to show that it was state's property. Nothing.
हस्तांतरण का पर्चा is what?
It's some simple, unregistered. By this document, the circle officer transfers this property to the police line for construction.
Is this your property, madam?
As per the counter.
काउंटर से नहीं, आप इससे बताइए।
इसमें तो है हस्तांतरण it has been transferred. So there are two.
Transfer कब होता है? When the property does not belong to you. Then only the question of transfer. How by this document the property can be transferred? Do you claim that it is your property? Is it government land?
From the records which it is apparent that it is a Rayati property.
Then इतना दादागिरी चलता है क्या आप लोग का?
Only one stand that has been taken leadership that notice was issued to the petitioner.
For what?
For coming along with the relevant documents, for producing the relevant documents to them. And he failed to submit the relevant documents as well as he failed
तो आपने क्या किया? जमाबंदी कैंसिल कर दिया?
identity that he was not in physical possession of the land.
Did you cancel the जमा land को physically कैसे possess करते हैं? How do you possess the land physically? उसमें खड़े होकर वहाँ खड़े रहना है whole life to show your possession. What is the mode of? It's a vacant land. पड़ा हुआ है.
Fallow land, which is even uncultivated.
Yes. How did you, is it your case that the property belongs to you? Is it your case? Can't be that we'll hold up, it can't.
One stand has been taken action that the Jamabandi was illegally opened
How?
without competent authority. So, Sunday Hospital considering it to be.
कहाँ से, कौन से ऑर्डर से संदेहास्पद इसको ऑर्डर नहीं है, काउंटर में है. There is no order. There is no order cancellation of जमाबंदी also. Then how do you?
ये जो सीओ का जो एक
No,
लास्ट
that you
था.
need to see. Annexure 14 is the ultimate conclusion of Sandhyaspad Jamabandi. The order is initiated, Annexure 14, and then the concluding page 72. This is the order by which ultimately my Jamabandi was cancelled. It does not reflect anything whatsoever, anything. I may be allowed to read. अभिलेख उपस्थापित जमाबंदी रैयत की ओर से इतना कोई अपने आप की पुष्टि दाखिल किया गया है. मूल कागजातों पर मिलान इतना छाया प्रतियों से मिलान किया. जमाबंदी रैयत का जवाब नहीं. प्रथम सरकारी रसीद दिनांक 31/3/1955, खाता संख्या सो कुल रकबा 2.50 एकड़ में कायम की गई है. आदेश अंतिम रसीद संख्या 22/8/97 तक निर्गत है. साथ ही जांच क्रम में कागजातों से मिलान में पाया गया कि पूर्व में स्थानांतरण अभिलेख संख्या 4/2001-2 के द्वारा प्लॉट संख्या सो में इतना एरिया पुलिस लाइन निर्माण हेतु हस्तांतरित किया जा चुका है. इसी के लिए जमाबंदी
This
प्लॉटों
is
का
post facto. After transfer.
yes.
It is not something that they found that it is wrongly opened and then.
Why my Jamabandi is being cancelled? Only on the ground that is has now been transferred to the police department. That is the only ground. Does not dispute anything with regard to my right, title, or royalty right to the property. It is so unfair of a private person's property taken away in such a manner.
Acquire कर लेते ना चाहिए था. Should have acquired the property. You can't. देखिए WPC नंबर 65. ये सब केस इतना दिन से क्यों पड़ा हुआ है?
क्या बोलेंगे? It is partially the fault of some errors in initial statement. But there is absolutely nothing.
But there was a specific order for you to file a para-wise reply to the counter affidavit by the Deputy Commissioner. Have you complied that?
Yes, that has been filed.
Most annual probably.
It has been filed in March 2020.
March
2025.
March 25. No, it's not there. Yes, it is here. It's not. You place your counter affidavit because the facts are very glaring.
May I read it?
You just read the relevant
Relevant
portion.
paragraph. It starts from
13.
paragraph 13, that it is only stated and submitted that the lands of Khata number 3 was recorded in the record of rights as land Mujibur Khas land of West land, and the land remained uncultivated because vested, unsettled in state to begin the owner and exercise all acts of possession and other land is specific and under the possession of state government. As such, the state authorities transfer the land by granting purchase and leaving the lot for construction of Forcible. Then it is humbly stated and submitted that the Jharkhand Police Housing Construction Corporation Limited Authority also released the fund and buildings have been constructed with the full knowledge of the petitions. And that Jamabandi was illegally opened in the name of the petitioner, and when the land in question was transferred for construction of the forest land, data was.
There is no order that the Jamabandi was illegally opened. How is he writing? This is not substantiated by any of the orders. Heard the learned counsel appealing on behalf of the parties, this petition has been filed for the following relief. You have filed amended writ petition.
Yes.
Why was the amendment sought for?
Yes, because paragraphs were of how the property was ultimately came to me, that was not very clear. Therefore, the Honorable Court had asked me to. And I have mentioned all the registered transfers. And there is one very important, two other documents are there. Annexure 9 is Bakas case number by which the ex-landlord's right was rejected, and it was held that in the proceeding under 567, it was held that I am the right.
Which is that order?
Annexure 9 at page 63.
Okay. This very property?
Yes. This property.
The learned counsel for the petitioner has submitted that the entire history in connection with the property involved in this case has been mentioned in the amended writ petition, and at the time of vesting, the then landlord fraudulently claimed the property involved in this case as his own property in Bakas case number 354 of 1958-59. And ultimately, the original petitioner had filed objection, which was decided in favor of the petitioner by order contained in order dated 31/8/1959 as contained in Annexure 9. The learned counsel submits that in view of the proceedings undertaken under the provisions of Bihar Land Reforms Act, it is crystal clear that the petitioner is a rayat of 2.50 acres of land and has title over the same. The learned counsel has then referred to Annexure 13, which itself is a document of the respondent authority, and has submitted that it has been mentioned therein that the Jamabandi is running in the name of the petitioner since the year 1955, and he continued to pay rent till 1997. The learned counsel submits that there has been no cancellation of Jamabandi the learned counsel has submitted that the petitioner is the owner of the property and has been paying rent since 1955 onwards. He then submits that as per Annexure 13, it has been also mentioned that Jamabandi can be regularized in favor of the petitioner. Aapke favor mein na? In favor of the petitioner. The learned counsel then refers to the Annexure 11, which is dated, date क्या है इसका? Annexure 11 का date
which is
Annexure 11, which is a report of the circle officer who has reported that the property involved in this case can be transferred to police line for construction of
police station.
Police establishment. And this was followed by Annexure 12, which shows the transfer of land in favor of the police establishment,
which include my 3 plots.
which includes the 3 plots of the petitioner. Those are
1323, 1324 and 1325.
1323, 1324 and 1325.
Area 1.42 out of total 2.5 acre.
Area 1.42
42 acre.
acres
Out of my total 2.5.
total area of the petitioner of 2.50 acres. The learned counsel submits that this was followed by cancellation of Jamabandi dated by the order dated 26/3/2003 merely on the ground that now the property has been transferred in favor of the police line. The learned counsel submits that the private property of the petitioner has been taken away and the entire action of the respondents is illegal and arbitrary. He has also submitted that during the pendency of the writ petition you were dispossessed.
Yes.
During the
time
petitioner has been
itself,
dispossessed and the construction has been made over the property.
Yes, and no compensation whatsoever was ever.
The learned counsel submits that if the respondents wanted to take the property, they could have taken it through land acquisition process, and the private land of the petitioner cannot be taken away in the manner it has been done in the present case. The learned counsel for the respondent has referred to the order dated 16/12/2024, wherein the Deputy Commissioner Chatra was directed to file a counter affidavit. And she submits that, as per the counter affidavit, the property is Gair Majurba Am.
No, Khas and Bakasmani.
Two different khatas.
Khata 1 was Bakasmani and Khata number 3 was Garbajarwa Khas.
Which is government land.
No. Khas means landlord's own property, but it is not being cultivated, therefore Garbajarwa.
The learned counsel has referred to paragraph 12 and 13 of the counter affidavit to say that the land of Khata number 1, plot number 1325, measuring 0.66 acres was Bakas land of ex-landlord, namely Jodha Pandey, Ruplal Pandey and Ishwaran Pandey and others, and the land of Khata number 3 was recorded as Gair Majurba Khas land of the ex-landlord, and the land remained uncultivated, which vested unsettled in the state, and therefore the property was rightly transferred through Parcha in the year 2001 for construction of police line.
One more parallel, para 23.
The learned counsel has also referred to para number 23 of the counter affidavit to submit that the petitioner upon notice had appeared before the circle officer Chatra but did not file his relevant documents during the course of inquiry, and the petitioner was not found in physical possession of the land in question. However, during the course of argument, it transpired that the specific statement made by the petitioner in paragraph 14 of the writ petition, by referring to the proceeding under 567 of Bihar Land Reforms Act, wherein order dated 13/8/1915 was passed in favor of the petitioner, has not been disputed in the counter affidavit. कुछ नहीं है ना? Annexure 9 दिखाइए जरा एक बार. Okay. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears that with respect to the same property involved in this case, an order was passed in favor of the petitioner in Bakast case number 354 of 1958-59, way back on 31/8/1959 under the provisions of Bihar Land Reforms Act. It is further not in dispute from the records that the petitioner has been paid rent to the state right from 1955 till 1997, as is apparent from Annex 13. There is nothing on record to even show that the property belongs to the government. However, on the report of the circle officer that this property can be transferred to police line, the property was unilaterally transferred, and post-transfer, the Jamabandi of the petitioner has been cancelled. This court finds from the records of this case that the private property has been taken away and handed over to police line without following the procedure of law. If the state was interested in taking away the private property of the petitioner, they could have initiated a proceeding for land acquisition. Accordingly, the impugned action of the respondents cannot be sustained in the eyes of law. क्या चीज आप challenge?
Annexure 12 to the extent it involved my property.
Okay. Accordingly, the Annexure 12, only 12.
12 and 14 is the order by which my Jamabandi was cancelled.
Annexure 12 and Annexure 12 by which the property has been transferred by Hastantaran ka parcha. And
only to the extent my
yes, and the order dated 26/3/2003 whereby the Jamabandi has been cancelled, both to the extent it relates to the property of the petitioner, are hereby set aside. The respondents, अब क्या होगा?
नहीं और कुछ नहीं.
अब आपको मिलेगा कैसे प्रॉपर्टी?
मिलेगा either they may acquire or they may.
The respondents are directed to either hand over the property.
That construction has already been.
So क्या हुआ?
So land acquisition का proceeding हो सकता है.
I do not know. If you want to demolish and hand over, they are you're most welcome. We can't ask you to acquire, right? The council, the state, who will do it? The deputy commissioner.
Deputy commissioner.
The deputy commissioner Chatra is directed either to hand over the property of the petitioner within a period of, or to take appropriate steps for the acquisition of the land of the petitioner, as the building appears to have already been constructed over the property. If needful is not done within 3 months, it will certainly be open to the petitioner to take appropriate steps for recovery of possession.
वो नहीं.
अच्छा छोड़ दो. ठीक है.
वो last line छोड़ दिया जाए.
ठीक है, last line.
I will have a right to approach this honorable court.
This petition is accordingly disposed of.
Your Lordship can also mention one state of Haryana versus Mukesh Kumar. This was a case where private property in similar manner was taken.
Para number दे दीजिए.
I have highlighted.
The learned counsel has relied upon the judgment passed by Honorable Supreme Court reported in bracket 2011 bracket close 10 SCC 404. Para number?
I have highlighted the portions.
ठीक.
That there was 25-26 year इसको किसी ने
कौन सा 25-26
ये
क्या?
आज का डेली का
डेली का 25-26 बेल है ना आपका?
बैच है
रीट केस.
रीट आज का आर्टिकल
क्या मैटर?
अपॉइंटमेंट प्रधान का अपॉइंटमेंट मेटर 2006 से
उठने बजे 4:45 बजे मेंशन का क्या मतलब है? ठीक है, ऐसा नहीं होता।